Welcome to Circle City Conversations, where the heart of Indianapolis comes alive through the stories of its people. Join us as we explore our city, one insightful conversation at a time.
We are back with another one of our inaugural episodes here with an attorney friend of mine back at the Mark Lopez Law Firm office up on the north side of Indianapolis. My name is Alex Limontes. This is the Circle City Conversations podcast, where we talk with some of the best lawyers and business people in the state of Indiana and in Indianapolis. So I'm here with Jamison Allen of the Mark Lopez Law Firm. Jamison is first and foremost a trial lawyer like me, loves trying cases. And Jamison focuses his practice exclusively on helping the victims of negligence, personal injury victims, wrongful death victims. So Jamison, thanks for joining me.
Thank you for having me. Thank you, Emmanuel, for your work.
So Emmanuel is the tech man behind all this. That's all.
I have no mic, so I sound a little weird.
Let's just start off with the easy, quick questions, right? What made you want to become a lawyer?
Well, it's a quick question. A question because sometimes I wonder, why did I do this? So I've always had an interest in politics and law. I was a strange child. My mom said that I watched the Democratic and Republican conventions every night. 1984, when I was
Reagan,
10 years old, 9 years old. Yes, Reagan Mars. Yeah. And so she knew something was off and talked to me about, over the years, about possibility of law. And it always was a possibility, but always seemed to be something in the future. Ended up going to college and majoring in theater as well as social studies education, minor in history. Taught high school for one whopping year before deciding, maybe I should try law now. And actually, like many things in my life, making a big jump, it's me getting angry about something and doing it.
Really?
So I got angry at something at school in January of 1999. And I was in the Champaign-Urbana, Illinois area. And this is really like the infancy or toddler age of the internet. And so instead of going online, I just picked up the phone and called the local law school and said, hey, how do I become an attorney?
Wow.
And they said, well, this is like late January. And they said, well, the last day to take the LSAT is like 3 weeks from now. Or at least to register maybe was like 3 weeks. And so I took the LSAT quickly, did okay, and here I am.
Did you, so where'd you go to college?
Went to Indiana State.
Okay. Terre Haute,
known for Larry Bird.
Go trees, right? The fighting trees. We actually have a lawyer at our office, Chase Wilson. You know, Chase went there. He went to Indiana State.
Right.
Yeah.
I met Chase at a common friend, mutual friend we have, who also went to Indiana State and married someone who went to Indiana State. And so we met at a backyard barbecue and not knowing each other before.
You didn't know that you would eventually practice in the same area, or maybe did at the time.
We did, and he was already at your firm, I think, at that point.
Oh, wow! Yeah,
but I had not met him yet.
Yeah,
then I met him at a ITLA event, I think, like 2 weeks later.
Okay. So you went to law school. Where'd you go to law school? You decided to go to law school. Where'd you go to law school?
Right there, University of Illinois, Champaign-Urbana.
Okay. Did you? I mean, are you from Illinois originally?
No, I moved there in 1996, and then taught high school there.
Okay.
And so then I was in that area, and so it was just a logical location.
Yeah. Did you ever practice in Illinois?
I did for 3 years. In Peoria, Illinois was my first job, doing general business, real estate, all kinds of work.
Yeah.
Does not fit me looking backward. Our firm represented Simon Property Group.
Okay.
With the Peoria and other Illinois properties. And then I also the firm represented schools.
Okay.
And so that kind of fit into my education background.
Was it more about like a general practice type firm or defense?
General practice. We did not do any insurance defense.
Okay.
But I never thought I would be a dirty ambulance chaser, right? And if I had known that, I would not have gone to law school because I would have thought that's not what I want to do. That's not who I am. But if I would have known the reality of being a plaintiff attorney, and then I would have. But the stereotypes are so strong, aren't they?
Mm-hmm. They are very strong, aren't they? And you know, some lawyers live up to them, don't they?
Yeah, this is recorded, isn't it?
Yeah. So we don't have to name any names, but you know, there are some that live up to it. So you did some general practitioner type work, and then after why'd you leave Illinois? What happened then?
I got angry at a situation. I don't remember the exact day. I know it was 2004. I had been an attorney in Illinois for maybe a year or so, year and a half. I guess that's what it would be. And then I had to take the Indiana bar. Yeah, I did it secretly, being the slimy future plaintiff thing, and had to study at night to do it, to come home to Indiana. And I do remember I was doing contracts as part of my practice, and I remember going through the Barbary books that I already had and I kept, and because the multi-state's the same, of course, when you take it. And I remember getting on my first practice test for contracts, I got out of 15 multiple choice questions, I got 6 correct.
Oh, wow.
That tells you how hard and meaningless a lot of these bar questions are. I was already practicing. Maybe I was just a terrible contractor. That's the alternative explanation. I don't really care to think about that. So then I did that, came over, stayed at a friend's house late July 2004 in Indianapolis at the bar, and then passed and got sworn in, and then came over here.
So you came over to Indiana. Where did you start working?
I went to Lee, Kossel, Keene, and Love.
No fact.
Yeah, Nathaniel Lee, Kate Keene, Marsha Kossel, and Robert Love, attorney from Fort Wayne, who was not in the Indianapolis office. And they do, as you know, a lot of plaintiff injury representation. And my thought was I would just do it for a while and then get a job as a contracts attorney here, where I, at the time, I thought I fit. And then due to being a plaintiff attorney, I didn't tell people, some of the people that I had gotten a job or I'd apply and had things in place. And so that they contacted me and then found out that I was a plaintiff attorney, and then they weren't interested in.
Really?
That is true.
So because you did plaintiff's work, it affected your ability to get a job doing contract work as an attorney?
Absolutely.
Wow.
Yeah.
Did they tell you that? Were they like, oh, yeah, you're an ambulance chaser, I'm not going to hire you, you scum?
That's something I figured out. And then I did have someone in a firm that I had interviewed with, a big name Indianapolis firm.
Yeah.
Big name. And he basically told me later on in a trusting manner, that essentially, in not so many words, that they thought that if I said yes to that, then I wasn't their material.
Huh. That's so strange. You would think that they would want people that did plaintiff's work working there.
It might be the area, the section that I was being considered for.
Okay. So you started doing personal injury work. You thought maybe you'd do it for a little bit. Then what happened? Why'd you decide, this is really what I want to do, is what I'm meant to do?
It was just a slow realization.
Yeah.
And then, you know what it's like when you get a result for a client in which they're in a situation in life where they're scared. No one's listening to them. They're not empowered, and they need help. And then you see how law works to help them. You know, in Indiana, we can't help them as much as we can in some other states, right? In certain circumstances at least. And so you see that, and then over time, it just fit my personality more. It fit, I think, my worldview more, and typically who a plaintiff is and who a defendant is. And so in all those various ways, it seemed to fit better. And then as an attorney, from an attorney standpoint, I found that plaintiff attorneys, I fit better with plaintiff attorneys.
Yeah.
And hard maybe because of my uncomfortable, my inherent uncomfortableness, discomfort, I guess, if you were right, with the in-person handshake, rear end blanking type of nature of what you have to do in certain areas of law.
Yeah.
And that just doesn't fit.
Little stuffy, maybe.
Yeah.
Too stuffy for you. So you worked with Mr. Lee. I'm assuming Mr. Lee, and you probably worked with a lot of the other lawyers there. Wow.
Yeah. So there were numerous litigators, and so I learned from Nate Lee, learned from, as I mentioned, Kate Keene, Marcia Tassel, Laura Crowley was there, wonderful attorney, wonderful person, helped me tremendously, and as well as John Lowry, Bob Chidley, others. Yes.
They do a lot of stuff there, including disability and some medical malpractice. Did you have an opportunity while you were there to kind of explore the different areas, sub areas of personal injury?
I did. Most of what I did and where I felt most comfortable, where it fit more, was with car crashes and slip and fall injuries, and that's where most of my practice then landed. But I ended up doing litigating a variety of cases.
Yeah, and for my listeners that aren't aware, handling a standard kind of car crash case versus a medical malpractice case where you have to go through a panel and everything in Indiana is very different.
Yeah, it's entirely different. And I was never I never litigated a mal case there from start to finish, but would play a role in a small way. But had my own file lists, and as most places are organized, and I had to litigate those cases in addition to assisting on a multitude of others. But that allowed all of us to see and learn from a variety of styles and personalities and experiences.
So after Mr. Lee's office, where'd you go next?
Worked at Geico Staff Counsel, driving around the state of Indiana, and seeing that part of it. I had become a little jaded with some of the difficulties on our side.
Plaintiff side, you mean?
Plaintiff side.
Yeah.
And I always respected the defense attorneys who practice the right way.
Right.
And the attorney there, Randy Lakey, who ran the office, he's a great attorney, he was a great employer, and practiced fairly. And I did not intend to leave there a year and a bit maybe later. But that was when Buddy Osha and Brian Tisch called me up one day and wanted me to go for lunch, and I didn't want to. And I was like, well, let's just plan it for 2 weeks from now. I said, no, we need to talk now. And then, Buddy's persuasive. And, so we ended up going to lunch that day, and then a few days later, made the decision to jump back to the plaintiff side. And then I was there until bringing my practice over to join Mark.
So, and for my listeners, Buddy Osha is a PI staple in our legal community, and he was partners with my partner, Bill Hurst. And so when Jamison says that he can be very persuasive, I feel his pain, and I know exactly how he can, exactly what he's talking about. So you're a trial lawyer, right?
I am a proud trial lawyer.
Let's talk about some memorable kind of cases, any memorable trials. We talked a little bit. I want to kind of talk about two of them. I I talked a little bit to Mark with Mark earlier about the case that you tried with Lisa Mitchell up in the body language specialist, our expert up north. And I wanted to talk to you a little bit about that experience and maybe ask you how you think that COVID has changed the jury trial landscape.
That's a good question. At the time, we were scared to try the case, honestly, because there had not been any trials. I decided to go out on my own during the pandemic, which was, kind of crazy thing to do. And then called Mark for advice. And then Mark is also very persuasive. Ended up not being on my own. He said agreeing to be the injury partner. But that was when I came over. We talked about cases that I had that I was bringing, and I told Mark, this case won't go to trial. Don't worry, it's set.
Really,
it's set for first week of August or second week of August, whatever it was. We can't, because it's not going to go to trial. They're continuing everything. They can't do it. And then surprise, we had a pretrial conference about a month before, and the judge said, absolutely, we're going. And so we said, oh, I guess we have to get ready for a trial.
Yeah.
And with the nature of the case, I mean, we already had a lot of preparation, general preparation, but you know how it is to line up witnesses and testimony, the thing that you can't do until later. And so, we had to focus on that. And then it was all a new landscape, because a lot of the things we thought would make a difference or how you try a case, we couldn't do that with the pandemic. I mean, during that time, they had people spread all out across the courtroom and wearing masks. And we thought, wow, if they can't see your whole face, how would they trust you, type of thing. And then they said, well, but if you don't wear the mask and they're worried about getting infected and maybe dying from it, they're going to like you very much if you take your mask off, right?
Exactly.
Then your client's going to pay the price for that. So what do we do? And then, of course, there are people who, if they see you in a mask and they think, and you have any chance to not wear one, then they make certain assumptions about you, and you don't like that either. So it was really difficult to do. And so Mark had a previous professional that had, I don't know how many cases he had with Lisa Mitchell before, but they had a professional history, and she was available. And so we hired her. And in regard to jury selection, she was absolutely essential to our decision, because she was picking up on eye movement and where the right shoulder in position to the left shoulder. Yeah. Well, this guy kind of turned his leg this way and spun just a little bit when you asked that question, and whatever the issues she picked up on, and she knew what all that meant. Where we might have, you and I might have reached the same conclusion based on experience, but we maybe wouldn't know exactly what led right to that. We know the right side of the formula and the other side of the equal sign, but we don't know what's on the left side. Yeah. But then you put the mask on someone's face, and it takes a while of that inherently away. Yeah. So we relied on her for choosing the jury, and then just did the best we could and just trying to pay attention to what the jury was wanting. And we made the assumption based on where we had the case, that we would have more jurors who would not want us to wear a mask than would. But we wanted to honor, even if we lost the case, we don't want to hurt anybody. Right. So we're going to honor all the rules. And we did. And then we figured out during the trial that we somehow ended up with a jury that was more pandemic sensitive than what you would think. And they even asked to spread out further. They asked the judge if they could spread out further. Yeah. And so it was interesting just trying to work through all those logistics of it at that time. Now, that's short-term answer. Long-term answer, I would say, the pandemic, I think, has changed the way in which juries view non-economic damages, which for those who maybe don't practice in this area or any non-attorney might hear this, that basically means a number that you can't document in a traditional way. So not medical bills that going to have a number, not a wage loss. That even if it's arguable what that is, it's still
A number.
a number. That you have so much an hour times this many hours, blah, blah, blah. But non-economic is, well, I can't tap dance anymore.
Right.
What's that worth? And that's my hobby.
Yeah.
What's that worth?
Worth something different to everyone, right?
Right.
Yeah.
And so that then becomes, and by the way, I don't tap dance. I do dance, but I just realized now that I said that's my hobby, people might think, oh, you're a great tap dancer. No. I just believe it. I'm just saying that if someone tap dance. But yeah, we soon, and I think it's fair to say across the board, we have seen increases in non-economic verdicts. And, I think that the pandemic changed the way people value life.
Yeah.
And the aspects of life that you cannot put a number on, or the value, or the aspects in which, when you had to put a number on it, the number should be higher.
Yeah.
And so people realize that the time with family is super important. They really saw the value of it.
Yeah.
Being stuck at home with these people,
right,
that live down the hallway from me, and then simply having the opportunity to do things taken away.
Yeah.
And that was all temporary for most of us, but still had tremendous effects on your mental health, on your physical health, on your relationships. It affects everything. And so I think it's become easier for us as plaintiffs attorneys to bridge that gap and help get a verdict that is closer to justice because of that common experience with the pandemic. And then, of course, there's all the politics involved and not necessarily even what you would assume, that there's some people on the far left and the far right that have the same distrust and corporations and with any large entity and status quo and so you kind of figure out where you can marry those people when you have both of them on the same jury. But I think that's probably the biggest thing long term that has changed. The pandemic has changed, and it's just a theory. But
right,
there something had to have changed in the way people view those elements of life for the change in verdicts to make sense.
Yeah. And I mean, it was all so fresh for them. They had just gone through that experience of being at home, being with your family, knowing what it's like to have your kids around all the time, and then having to go to a jury trial and having a lawyer stand up there, not only respect your space, and personal health, from a COVID perspective, but, also they were just living that. And then you explain that to them. And I do have to commend you and Mark bringing Lisa on, especially during COVID when people had to have masks on, was smart because you can't read their facial expressions. And I, as a trial lawyer, that's when I really see what they're thinking, especially during voir dire,
Right.
Yeah.
Yeah. And it's, we never learned, at least I never did, even though I started to read more about psychology since then, once I realized how important it is in understanding people as quickly as possible. But I never knew, like I said, the left side of the formula. Oh, I saw the eyebrows do this, and that's why I now have a suspicion that this juror is reacting this way to what I said. But we intuitively know these things. No one tells us that, when someone makes a sour face and recoils from you, that means that no one tells us that, right? Like you figure it out in life. And so it's that type of reaction, you're right, that you would try to rely upon. But when that mask is there, it's harder to see. But yeah, at least it was incredibly experienced with it. And the eyes are still visible. And she said, I think she said that was the most important part for her.
Yeah. And you guys got a great result with your client on that case, didn't you?
Yeah, I think we got a great result based on your facts. If I would have known what the jury was thinking, we talked to the jury afterward. They're very helpful, very generous with sharing their thoughts. And if I would have known how they were perceiving it, I would have structured the closing a little differently. And I think we could have done you better. But you don't know that, do you?
Until hindsight. Hindsight's always 2020.
Yeah, and so where I thought they would see the greatest loss and the most value in regards to the verdict, they did not, and they saw they put more value where on the part of which I thought they would see less.
Right.
And
It's crazy, right? I always tell everyone, well, I'll be sitting at a mediation with a client, and I say the same thing every time. No one knows what a jury's going to do, because you could try the same case 10 times and get 10 different results, because you get 10 different sets of people on there. As to your point, you thought you were probably going to get some more folks on the jury that didn't necessarily care so much about wearing masks and things like that, and it was the opposite,
Right. In that jury pool, it ended up being the opposite. Now, you're right. You get 10 different results. And in this case, I think we might have gotten the same result, but we got there a different way.
Right.
And therefore, if I had structured it differently, it could have even been a better result. You don't know. And so you have to play the odds, and everything that we do, right? It's race, playing the odds. It's assessing risk.
Yes.
And likelihood, and then doing the best we can, fighting as hard as we can in that system, within that structure.
You mentioned you were a theater major. Have you used any of those skills in the courtroom?
I've never danced in a courtroom. Perhaps I should try.
It would get their attention, right?
That's it. And I've never given a interpretive dance closing. Maybe I'll do that in my very last closing of my career, and go out with a bang. But I think every experience I've had in some way had to come into play. So I am not a natural public speaker, and that was true regardless of the amount of performance experience I had as in theater, as a musician. And so what I found different in theater is that I became a different person. And so I didn't need to worry about public speaking. And it's not the same. You don't make eye contact with everyone in the audience because it's not a speech giving. You just try to react to your fellow actors. And so that became, easier though, because just being there and having your body influence and yourself being the part of the art certainly helped. And then I think that I certainly have learned the importance of telling a story.
Yes.
For a jury. And so having that type of experience in the art, I never was a good writer, playwright or scripts. But I did direct some shows, and you're telling a story. And so I think that helps. If you're through a parallel to theater, I guess the first chair attorney would be the director of the musical.
Yeah.
And then, the producer would be the firm overall.
Right.
And then you have to, the actors are your witnesses, and the analogy probably not that great, but you get the point.
Yeah. Yeah. So I'm gonna open this drink, this Coke. They're not a sponsor, so. So we're talking about stories.
Gave away free money there.
Right. Yeah. We were talking about stories and the case that you tried really like at the height of COVID. You did within the last couple years, year and a half or so, get a really significant what I would consider a landmark type of win, particularly given the hill that you were having to go up to fight this battle. So if you don't mind, just tell me a little bit about that case.
Yeah. So in that case, we represented an elderly client who was walking to her car, leaving the store, walking to her car, and walked behind a car that was then backing up as she stepped onto the parking lot. And the insurance company, it was her insurance company, so who fought it all the way to trial. And we were able to get the policy limit very quickly from the driver's carrier, as you would expect. But of course, they didn't admit fault. And then our client's insurance carrier maintained the appropriateness of arguing for a defense verdict all the way up till closing. And they argued for a defense verdict, saying that it was more our client's fault than the driver's fault. And I never thought it was a good argument. But, there were some facts they could cite that, the car was there, so that our client said that she thought the car would have to back up when it left in order to, because there was another car in front of it along the curb, and so they couldn't just pull out.
Okay.
I think that actually is right. It could have. But my client said that she thought that, probably would need to back up. So there were facts like that her insurance company grabbed onto and blamed her. But the part of the case that was most difficult, the reason why the insurance company did not offer enough for my client to settle was her age.
Yep.
And
talked a little bit about that. That's something I know about it. We see it all the time. How they what kind of value they place on that.
Right. So my client was 88 or 89 at the time of the injury, 93 at the time of trial. It's just the way it takes until most cases get trial. And every time I talk about this, even to other attorneys who do not practice injury law, but in particular when we speak to non-attorneys, family members and friends and other people about it, they are really surprised. But the way insurance companies value these claims to elderly people is with an approach of thinking, well, you don't have as long to live. You weren't doing as much anyway because you're an old person. Your health wasn't as good. This didn't affect you as much as it would have affected a young person, so we're not paying as much.
It's terrible.
And so, that's the way, as plaintiff attorneys, we validated that essentially because that's the way that we said, well, it's not fair, but that's the way it is. And there were a lot of verdicts that indicated that the insurance company were right. And so they would go into trial and they wouldn't make those arguments with those words
right
to a jury, not if they were smart, but they would essentially get the jury to think that or evaluate the case in that way. And then, of course, the way in which plaintiff attorneys in which we try to blackboard damages, blackboarding damages, meaning giving the jury a framework to calculate the verdict and what numbers you put up, sometimes on the whiteboard or blackboard, in a PowerPoint or whatever you're using. The way in which we've done that historically has often been, well, this is a permanent injury. They have to deal with this every day for the rest of their life. This plaintiff is 42 years old. A 42-year-old, if you look at this chart here from the government, it says that their average expectancy at this means. So this means they're going to live, this many days. They're going to live 14,212 days more. And so if you have them, give them $100 a day to compensate for what they have to go through, that's the way in which we did it. And so that does allow an insurance company to come back and say, well, of course, this elderly person's case isn't as valuable because we're using your formula.
Yeah.
Formula all you attorneys use. And, so on average, she only has 600 days left. And so that's at $100, that would be $60,000, right? So that's the way in which insurance companies approach it. With credit to my client, she had an umbrella policy, which for those people don't know, and I did not know what the heck an umbrella policy was until I was a plaintiff's attorney, but it covers you, it protects you if you get sued. But in this situation, her umbrella policy also protected her if she got hurt by someone who did not have enough insurance. And umbrella policies are usually pretty big, usually $1 million, $2 million. And so in this situation, we were fortunate that we could fight it this deep and go to trial because there was coverage. There was an umbrella policy on it. And so the maximum that we could recover was $2.25 million based on her underinsured motorist coverage plus the umbrella policy. And so she was smart to get that. And then because she bought it and never thought, and she and her husband, her late husband, and actually she's deceased as well. She died about 3 months after the birth. And so, but she did get their compensation distributed to her
And justice.
and got to, then decide how she wanted the money to be spent, invested in family and her church, etc. But her late husband and she had decided to get this umbrella policy. Never thought they would use it, but then the rare thing happened in which the insurance company should pay, but they were not offering close to what she thought was fair, and went to mediation twice, and the mediators told us that should settle the case at the number that was being offered. And it wasn't even close, like it's a close decision, but wasn't a difficult decision for her, and went to trial, and then ended up getting a $3 million verdict. And the most important part for the verdict, though, was that it was 100% fault on the other driver, 0% fault on her. And, her health was still bad at that point. We were really worried about her surviving through the trial. So she wasn't able to be there. She was at the trial, parts of the trial, but she wasn't there when the verdict came back. But I remember calling her from the courtroom on speakerphone with everyone on our team and being able to say 0%.
That was great. This is probably one of your best moments, right?
Thought we didn't do it.
Yeah, because nobody believed her.
Yeah, her own. I still can hear her voice in her.
That's all right.
Her son. They'll disagree. Great love that I didn't know I'd ever get in my career. Because so many things had to happen to make that possible. And some of it was just absolute dumb luck. And so things that happened, the case could have settled, but it didn't. Certain decisions that the shortcut way, looking back, just from an objective standpoint, I don't understand them. I don't understand why they thought that was going to help them. The fact that they went all the way until the last words of closing, laying her, not even saying 50-50, because for those who don't know, in Indiana, you can do 50-50, a jury can do 60-40, 70-30. There was a case recently, what was it, 78-22, something like that?
I saw that. Yeah, 78-22.
Some weird.
Yeah.
But so long as the plaintiff is not more than 50% of fault, plaintiff can recover, and then you get that percentage of whatever the damages are. So they could have done that. They could have said, look, we think this is the 50-50 case. Two people had to make a mistake for this to happen. I mean, I don't think our client made a mistake, but they could have argued that, and that would have, I think, the jury would have respected them a lot more.
Yeah.
But they didn't do that, and then even when they argued it, they wouldn't argue it really and can defend it and back it up. They just said, well, you're going to get this form that allows you to put defense verdict here. Say you're ruling in favor of the insurance companies, and we're not saying you should do that, but
right.
if you look at all the evidence and that's what you decided, then this is what you do. And so that they couldn't even stand behind it, and then it just opened the door to us on rebuttal.
Do you think that probably helped you? They would not say what they mean. They just danced around that bush, and they wouldn't actually say it.
Right. And so on how it is, where you can, even when you take a case, sometimes you'll think about, okay, if this goes to trial, this is what I'm going to say on rebuttal. This is what I'm going to say in opening, whatever, right? So you can prepare for what you think it's likely to happen, right? But you don't know. I thought I had really screwed up in closing, that I had delivered a terrible closing. And then, of course, they had their opportunity and then I come back on rebuttals. And it just made it so easy to stand up and saying, they can't say it. You know why? Because even they know it's wrong. Even they know it's wrong. And that's why they can't tell you to do it. And they can't back it up and stand there and say that's the right thing to do. They just want you to do the dirty. I don't remember the exact word they said, but it'll stop it long. Yeah. And so point was, I think before I got it off from these, can you believe that Jamison Allen out one bandits? Unbelievable. When did that happen? But, several things had to happen to go right. A lot of it's hard work and preparation, and then some of it dumb water. But the most important part always is going to be who your client is.
Yeah.
If you don't have a client that the jury wants to help, don't take your case to trial. maybe not even pick a case.
Right.
That was the biggest difference. And so it becomes easy to get a fair verdict when you just got to get out of the way of your client. Don't get in their way.
Right. And I mean, I will say, man, kudos to you for taking that case to trial. I mean, that shows true grit right there as a trial lawyer when you are dealing with a situation where anyone that's listening or that's done any plaintiff's work, we all know cases are evaluated based on the age of the plaintiff is such an important factor. And to throw that aside, knowing that everyone is going to be looking at that as an important factor, shows, in my opinion, a tremendous amount of courage and guts on your part, Jamison.
Thank you.
I respect you for that.
Yeah, it's easy when your client is saying, hell no.
Yeah, right? It is. Yeah.
That becomes easier. But since then, it feels like, we've played a role in changing how insurance companies look at these cases. Maybe it's not been enough time to know for sure, but I get calls from different attorneys, different parts of the state, saying that they got more in a settlement than what they anticipated, and so maybe my client had a role in that, in doing it. Maybe not every case different at work. Every case is determined by its own facts, right? But we were very obviously conscious of that reality,
right?
And how to value the case, how we present it to the jury. And one of the reasons why we saw it traditionally, why we think that most cases aren't valued as high by insurance companies or by juries, that the verdicts aren't as high, is that, the family's going to get the money. It's not even going to go to the person who was hurt. It's going to go to their kids, go to its grandkids, or whatever the case is. And I think that is a legitimate concern. There are people who think that.
Yeah.
And then, we just thought about issues like that. And it's easy for me to say, well, the problem is, and Mark doesn't like me. I want a solution, James.
Right.
Tell me the problem. Tell me a solution too. Excellent point. And so we just had to stop and think, okay, let's not worry about the injustice of it all. Let's just figure out how do we get around it?
Yeah.
And so the obvious answer there is, well, make the jury okay with giving the family money. Is there a way to do that in your case? And so in our case, we had to work toward that. And then when you're dealing with good people, it becomes much easier.
Yeah.
We don't have to worry about that. But not every person have a personality that is, warm and fuzzy, and to where a jury immediately will like a person, right?
Yeah.
And so, you have to consider whatever your facts are and what are the likable things about this family, the people who will get the money. How can you work them into the trial, in which obviously you got to prove your elements. But part of what you're doing is making the jury okay with giving these undeserving people money.
Yeah.
And not to tell you this, but the injuries that she had, severe injury that are life-changing, that doesn't just affect that person. It affects the entire family. So her son had become her caretaker. She was a caretaker her entire life. And then it flipped. And now he's having to take care of her. And that was so difficult for my client, as you can, people who have family members, or maybe anyone listening, have been in that situation. If you're a caretaker and now you're being taken care of, it's the most difficult thing to deal with. Because now you feel like you're a burden and your purpose in life is gone, and right. And they're all, people shouldn't think that way, but it's the way you're part of it. And so we focused on the things that he had to do to help her, which established the effect on her, obviously, but it's also establishing how his life is turned upside down.
Right.
Right. And so, I think those things might have made a difference, but we might have just had an amazing client with an amazing jury at the right time, and it all worked out.
Yeah. Well, you never know when it's going to happen. That's why it's important to have that courage, or sometimes I like to say legal cojones, to take that case to trial. I've had the pleasure of doing these first party cases We talked to Mark earlier about there always being a villain in the story. When you were trying your case, because there, in my opinion, there seems to be a bit of a divergence between some plaintiffs' attorneys. In a first-party case, they vilify the insurance company, which I've done before and has worked, or they focus on the damages of the plaintiff to try to drive those damages up. Was there an approach that you took, or was there like a hybrid, maybe?
I think it was a hybrid. I mentioned that you need some good luck,
right?
Litigation luck. One of the good luck things that occurred to us was the driver, whose insurance policy, carrier had paid policy limits, she disappeared. No, we couldn't.
You had an empty seat? Oh.
We didn't in the end, but she disappeared and we couldn't find her, at least not without a whole lot of work. And then we actually stopped trying once we then sat down and thought about strategy and thought, well, it's actually better for us not to make a tremendous effort to find her, because we could have that empty chair and say, they don't even have, the decency to show up, right? And so you have that benefit. Plus, if she did show up, maybe there's facts, or even if they weren't facts, but she would say they were, right? Like she could testify to things that we wouldn't know. So there was a surveillance video, it was really grainy, the grainy video.
Yeah.
That wasn't really easy to see some things, but there's no audio, and they were close enough that there could have been a conversation between them. My client said there was not, but this driver could say there was. So the driver could say, "Oh, I told her I was backing up." Who knows what the driver would say, right? So we didn't go after that driver, but guess who did and found her? The insurance company did, and thought they had a great witness. And when we did the trial deposition, they did not. And you can see, you've been in that situation before where something doesn't go the way that you were confident it would, that you were, someone has not been honest with you. There's something that you don't want, and you try to act like your soul's not being ripped out of you and nothing is happening, but you really can't. And I remember looking at the defense and kind of seeing that moment, like, oh no, this is not going to win. But this driver was quite vindictive and blaming.
Wow.
Yeah, no remorse.
Oh, so you got it from the insurance company and from the driver.
Right.
Wow.
Yeah, she felt like she was the aggrieved party, that she was dragged through this horrible, litigation, and she had a life to live and whatnot. And so we ended up with a villain there.
Yeah.
And if she's listening, I'm not saying personally or et cetera. But it certainly allowed, the jury proceeded and allowed us to, set it up that way. And then her own insurance company that she relied upon and paid premiums for years and years now is blaming her. And, so the jury didn't like that, obviously. And like I said, we were able to tell her, call us in the courtroom and tell her that, no, you were right. You had nothing wrong.
That's great. What a moment, right? Well, Jamison, I got to say, it's really been a pleasure coming up here to talk to you. Anyone listening, Jamison is a true legal mind. He loves talking shop. He'll tell you he's not a marketer. He's not that guy. He just wants to try to help as many people as he can. And
is that a backhanded compliment?
It is.
I think I heard a backhanded compliment.
It is. So, and I'm not going to mention the advertising lawyers, but put this guy in a courtroom any day instead of on a billboard, and his motivation is his clients and trying to help them. So Jamison, I'm going to make you tell people your email address so they can email and call you with all of their legal questions, since they all know now that you love talking shop. So how can anyone get a hold of you?
Yes, it is Jamison at indieautoinjury.com, which sounds like I do have a billboard with that email address, right? So hi, S-O-N at INDIAUTOINJURY.com.
Was that Mark's choice, the domain name?
How did you guess? How did you guess that?
That's funny.
Yeah, that was already purchased before I made the phone call to him. This is where it was. And then our firm number 317-632-3642. I do want to thank you for the opportunity to meet with you. I think it's great that you had the concept of doing this series, and I really value the professional opinion and experiences. And by the way, one thing I didn't mention that I should have at some point, I got so much help from a legal strategy standpoint from so many people. So the Indiana Trial Lawyers Association, it was full of generous attorneys. We're all competitors, but for one thing, I think we all believe that a rising tide lifts all boats. So yes, if you can get a great verdict in certain circumstance, when we get some similar facts, we now are going to get a bigger settlement offered from the insurance company, or we're going to be calling you and asking how you sit so I can imitate you and try to get big verdict. But also people in it, like we don't do this. Some of us at times can make a lot of money, but we also can lose a lot of money, and it's very risky. And everyone wants to practice injury law until you have to pay a whole bunch in expenses that you might never get back. And then it's like, well, we're angle. But we don't do it for that, but we do it for the results. And when you do it for the results, you help other people. And I got help from so many attorneys. I'm not even going to want to mention here in the moment. Sure. I'm going to forget and someone will listen. People like,
I'll get those names from you and make them come on the podcast.
Hey, that's a great way to do it. And so with this, anybody that's listening, reach out to, attorneys outside your area, reach out to attorneys, within your area and reach out. We're here to help.
Yes. That's a great point. Thanks, Jamison. Appreciate it.
Thank you so much.
Thanks for listening to the Circle City Conversations podcast. Be sure to subscribe so you don't miss out on more future conversations.